describe it in the space of a page, you're going to leave left out. But as a trial lawyer or a lawyer who has at least tried cases, what's left out is a lot of what we do. Okay. So what's going to happen, just to sort of cue this up for the rest about jury selection and what's going to happen is well before the trial, and sometimes jumbled up in the calendar with dispositive motions, which is most frustrating because you don't know whether the case is going to get thrown out. You need to resolve the rules of the road for the trial. And what do I mean by that? Well, you've got a lot of the rules of the road right here in the Civil Procedure Code, and they're local rules. But what is the rule as to whether Section 17041 of the Business and Professions Code of the State of California allows evidence of past conduct going to pricing? And it's better to hash that out before you go into a trial where that's going to be an issue. And so one of the things that gets settled before trial through what are called in limine motions are all of these issues that the parties can anticipate are going to need to be resolved so that the parties know what evidence they're preparing to present. Then once that happens, you need to exchange with the other side what evidence you expect to present. You can't just show up in court and say, I have in my hand a document that I would like marked as Exhibit A, plaintiff, right? You have to have alerted the other side, these are the trial exhibits, you have to alert the court. And that's so that things move more smoothly. But it's a whole lot of front-end work. If you've got a 3-week trial, you could have 2,000 trial exhibits. And you need to get them all ready, meaning they're copied, you've got them in order so that the trial attorney can turn to someone who's handling all this stuff, this crush of material, and say, I need Exhibit 42. And then 42 comes, and you are going to try and get that in the trial. So what is the evidence? And you'll hear about that in your evidence course, but it's not trivial to get evidence into the record. If it's a document, you have to authenticate it. You can't just come in and say, I'd like to introduce the plaintiff's marriage license into evidence. Well, first hand it to somebody and say, do you recognize it? What is it? Oh, that's my marriage license. And there has to be some foundation for that they would know what the marriage license is. So anyway, all of this is going to go on before you get to the stuff that this book describes. Then, of course, there'll be you've seen this all in the movies, right? There's an opening argument, plaintiff puts on their case, defendant moves for judgment, not, a judgment on just the evidence. There's no reason for us to put on the case because they can positively put that to the jury, and the judge says, well, why not? Okay, so you lose that motion. Defendant puts on their case, there's another round of motions, and then there's, that's submitted to the jury. Now, one of the things I did want to really drive home to you is this, by explaining this about the trial. What lawyers do when they get a case initially, it's a litigation matter, is they start thinking about their opening and closing arguments. Because you're going to have to figure out how to present all this complex material to a jury. It's not that easy. I mean, imagine a patent case. I mean, you've seen the Markman case, or a very small part of it.